Mr. Thompson.
Thank you, Your Honor. May it please the Court. Counsel. This appeal arises from a challenge to a notice of child care assistance overpayment issued by DHS. The fighting issue here is whether the DHS process for recouping payments that a child care provider elected to receive during the pendency of an administrative appeal satisfies due process standards. Because it does, this court should vacate the Court of Appeals decision and affirm the district court. Clearly, I should begin this morning by directing the court to Chief Judge Vogel's dissent in the Court of Appeals. In that case and in the companion case, Andrance, Chief Judge Vogel summarized really in 6 pages the appropriate framework from our perspective for how to analyze this case. I'd like to use my time to address kind of the 3 main issues. One is the existence or lack of the existence of a protected liberty interest, the adequacy of the notice that was received by the provider, and then the request for attorney's fees and whether 625-29 exceptions apply to that.
On the property interest, Mr. Thompson, could you clarify something that I'm a little confused about? It seemed to me that DHS was originally going to take away the registration of the provider and then ultimately said, I'm not taking away your registration, but we're ending the contract. Is that correct, or am I misunderstanding?
A little bit, pretty close. So this appeal is subsequent to an earlier proceeding, and in the earlier proceeding, the notice that was received, and you've got it in, just for the record, notice of decision is in the appendix at page 224. There were actually 2 things that started this. One is a notice of revoking the registration of the provider, which is one thing, and then a separate notification of a termination of the child care assistance provider agreement. Simultaneously, those were appealed, contested case, hearing, ultimately a final decision by the agency that reversed the decision to terminate or to revoke the registration, but affirmed the decision to terminate the child care assistance provider agreement effective the date of the notice, which was May 20th. So the registration remained. The agreement, which is the basis for a provider's ability to bill and receive the payments, was terminated.
It strikes me that one could have a property interest in a registration. That seems to me, kind of my impression of more a property interest type of thing, but a prospective termination of a contract such as DHS attempted to do here might not be something that there would be a property interest in.
Well, and I think the issue here is even narrower than that. In other words, the issue here is the recoupment issue, the due process related to the notice and opportunity on recoupment. But I want to address something you said, because I think it's real important here, which is the child care provider assistance agreement is kind of the core issue. And that agreement itself, and this is more reflected in the decision in the interest case, frankly, has got very specific provisions. It's a condition of receiving payments. Payments are conditioned on the term of the agreement. It can be terminated by its own terms with 10 days notice. And so that agreement relates to the payment provisions. The licensure and registration issues are related but different. When you look at the framework, the statutory framework for 237A, one of the interesting things you'll see is there are very specific provisions for licenses and registrations that clearly reflect that there's a property interest because it requires notice and hearing before you can revoke. There is not a similar provision for the child care provider agreement that we're talking about. And so one of the things that I want to get to is is the more specific provisions in the rules that deal with the methods of payment and billing put some specific limitations on what we're here to talk about, which is a narrower issue, I believe, than this broad question about whether there's an entitlement to all payments. I want to talk about kind of the Court of Appeals approach to that. The issue here is whether there's more than just an expectation. There's a vested entitlement to keep the payments you elected to receive when you pursued an appeal of the termination of your contract. So it's a pretty narrow issue. And when you look not only at the statutory framework, but the rules under the series of rules 170 and below, and even the appellate rules in Chapter 7 of the agency rules, it's absolutely clear that accepting benefits, assistance, payments, depending on the angle that you look at it, pending appeal is always expressly conditioned on the fact that if you lose your appeal, if the agency decision is upheld, you'll have to pay it back.
Before I'm going any further, and I understand where you're going with that, I want to make sure I understand the type of contract we're talking about. Is this what's referred to on the other side as protective daycare?
Protective daycare.
Is this what's provided, for example, for families in juvenile court who cannot afford daycare and DHS lines it up?
Yes. I mean, I think fairly
okay.
that is. There's some other categories here. And so
I'm just interested in knowing that because I have a feeling you're going to get to some of the equitable arguments, and I want to make sure I understood that I'm thinking about the same program that helps families in child welfare situations.
Yes, it is.
Okay.
This is essentially one of the qualifications for assistance that is given to the families, but then can get paid to a provider pursuant to this framework.
Right. It never goes to the parents. It goes straight to the babysitter, right?
Exactly.
Thank you.
Exactly. And so, I mean, when we talk about the property interest, the district court kind of just assumed there was a property interest and found notice was sufficient, which I think is fine. I think we'll find that notice was sufficient here with regard to payments received during the pendency of the appeal. And I do think, though, that Judge Vogel's decision took on this issue and reached the right result. And I want to be specific here because I think that both at the district court level in Indris and in Judge Vogel, in her opinion, even in Pfaltzgraff, that the discussion was kind of this general qualification. I think she correctly pointed out that the right to receive payments under this statutory scheme is expressly and generally conditioned on you being a provider, number one, and expressly conditioned on the department's billing and payment provisions. Those are words right out of the statutory framework. And the agency, at the agency level, the department has argued, Judge Vogel commented on this idea that at the very end of the statutory scheme, at 237A 13.8, there's a provision that says nothing in this section should be interpreted as creating an entitlement to assistance. Okay, that's kind of a generic, fix.
Oh, but she wasn't getting assistance.
Well,
or was she?
And that's why I want to take a step further. I think there's some ambiguity there. I actually think she is, because even the opposing counsel invokes provisions in the rules under the 7 series that deal with assistance being maintained during the pendency of an appeal. And so remember, the assistance goes to the families, but the provider under the statutory scheme can get the right to receive the payment. So absent the assistance, there is no payment to be made. So I think they're connected, but the way I think the better way to analyze this is not to rely solely upon that general intent provision at the bottom of the section, but to look...
Under your last statement, it seems like the people who are getting the daycare have to pay it back, not the daycare provider, because they're the one getting the assistance.
Well, no, because again, that's why if we look at the specifics of both the statutory scheme and the rules that implement the payments and the billing, which is the 170 series of rules, I mean, it expressly conditions, this payment at all on a number of things. Number one, obviously, the family has to pick you. you have to enter into a child care assistance provider agreement, which is a contract. You can find the contract. It's a DHS form 470-3891. You can find it.
I'm going to jump in here because I want to really get you to the equitable argument. Let me give you all of your arguments. Let's say if there's a property interest that, or let's say even if there isn't a property interest, what if I were to say I think notice was good? Suppose I go all the way down the path of Judge Vogel's opinion, but it gets to that equitable aspect. Help me with that. This, especially in the Endress case, I'm glad you brought it up because I wasn't sure if I could, since that's technically not the one that's at issue today. But I think we have all the same lawyers. There was a 3-year delay, and for whatever reason, I know the state's not asking for interest, but wow, somebody earned that money, and I think everyone agrees it was the babysitter, not the family. And so I'm having a really hard time with that equitable argument of why should the state get it back?
Right. Well, I mean, first of all, I don't think the equitable arguments are preserved or in this case.
Let's assume that they're preserved in one or both cases for the sake of argument.
But I do. I understand. I mean, I think that the due process issue, though, I mean, and I'm going to answer your question, but the law is well settled that, just because there's a wiser or fairer process, that doesn't violate due process as it relates to a property interest. There's either a property interest or there isn't, and you get adequate notice or you don't. I mean, under the recoupment provisions that we're talking about, I mean, from the very beginning, providers are given an alternative. When they choose to appeal, they strike yes. I want to keep getting my benefits. I may have to pay it back.
And I understand all that. I mean, I think that was the choice that these providers made, but it does seem kind of unfair for DHS to be getting services for such a long period of time, for free, in effect. So, what about this unjust enrichment claim? It does seem like that fits into the mold of what Justice Christensen was talking about.
It does. I mean, first of all, I don't think it lies against the state under these circumstances.
And why not? I mean, if you have no valid contractual right, which I think was settled in the administrative proceeding, the original one, then why isn't there a basis for unjust enrichment? And it did seem to me it was raised in the administrative process. It was raised in their opening brief on appeal. Why isn't it before us?
Well, I mean, the district court judge here specifically said it wasn't properly before and didn't rule on it. So, I mean, it hasn't been preserved to be up here on appeal with regard to appeal from the district court decision, at least in this case. But let me address it. I mean, it's what bothers everybody about this case. Like, oh, come on now, this is crazy. It may be a bad system. It may need to look at it, but the recipient, the persons that benefit from getting the assistance kind of for free are the families and the children. And the care continues to be provided. And
if we take that argument further on down the road, let's say that lady gets smart. Her friend who also had the contract, she said, hey, I signed up for payments during appeal and I got stuck with $36,000. Don't do it. So suppose that lady, the second gal, says, I'm not doing it during the appeal. I'm backing out. Carry that on down the road. What's the state going to do? You're going to have to pay somebody because those families are out there that need that protective daycare.
That's right. But there's a policy decision here, right? So there's a couple of policy decisions here that, as you know, when you focus on a specific fact pattern, you can say, well, boy, that doesn't work out. But as a system-wide thing, if you look at all the rules, if you look at the statute, the rules under 170 series, and the appellate rules under the 7 series, all of which relate to this thing, there's a preference here for continuity of service. It goes through everything. In other words, not just the assistance to kids and families that don't have a provider. There's different layers of it. No matter what type of facility they're in, the preference is, both under the appellate procedures in the rule and under the billing practices, that the default will be continuation of services. And
that sounds wonderful, but I think I'm pretty sure that it doesn't happen that smoothly. We're grossly short on those kind of services, and families are in dire need. I want to jump to the one more thing about this equitable argument. In the Endress case, DHS addressed her claim on unjust enrichment and rejected its application at the administrative level. Isn't that enough for judicial review?
In Indris, yes, I think you're right. I mean, I think it was, if it was ruled upon and preserved and the court ruled, I'd agree. But I think that, I mean, there's a different question. I mean, the appeal before you is about this notice and this recoupment. The allegation from the very beginning, at least in this case, has been that this whole process fails due process, and that nobody knows, there's not adequate notice, and that there's this entitlement that the Court of Appeals found to pay any payment that you seek. That is not supported by the record. There is not an absolute entitlement to any payment that you assert, or an entitlement under the framework created by the law. In other words, a due process right, you look to the state law and rules to see if it creates an entitlement. It's undisputed that it doesn't create an entitlement to keep payments that you took knowing that you would have to pay them back if you lost your appeal. I think that solves the due process issue. I think that the notices are absolutely clear that that was what happened. I mean, you can look through it. I'm not going to wade through it. All the courts have said there's enough.
Mr. Thompson, you could sum up. Your time's up.
Oh, I'm running out. I'm sorry. Well, the bottom line is I think that the rules in the due process here, I think the answer is like Judge Vogel said. There's really no anything other than a mere expectation or an argument that it's unfair, and that there is adequate notice. I mean, the unjust enrichment claim is an equitable claim. I don't know that it is really a claim that can be asserted, in the context of this administrative process. Maybe there's a remedy for equity here because it does, shout out for a remedy, but I don't think this judicial review proceeding is how we solve it, and I don't think declaring that a process and a scheme that satisfies due process, declaring it unconstitutional is the way to solve that problem. And so, Your Honor, with all due respect, if there needs to be an equitable remedy, I think we search for it in the right way, but that doesn't mean you throw out a complicated statutory scheme that the administration of an important program. Thank you.
Thank you, Mr. Thompson. Mr. Nelson.
May it please the court, counsel. I'm going to say I have the honor of representing both Julie Pfaltzgraff and Terry Enders. Ms. Enders is here today with us. Ms. Pfaltzgraff unfortunately couldn't make it. Before I get into the facts of this case, I have preserved a number of arguments at every level. The very first argument I made at the administrative level was unjust enrichment. And I have argued that throughout the course of both of these cases.
Did the district court rule on it in both cases? Sorry.
I don't believe I made the argument at the district court level in Pfaltzgraff, but I don't believe Judge Rosenberg specifically ruled on it.
Didn't Judge Rosenberg say, because I find due process is bad and all that business, I don't need to go there?
That was his entire argument, and I believe I did do.
I thought it was Romano's order that did not rule on unjust enrichment or any of the equitable arguments.
Judge Romano said that since she could find a remedy in law, she wasn't going to go to the equity argument. Now, I argued it in Pfaltzgraff. I think I did a 1.904 on that issue, actually. I don't recall off the top of my head. I wasn't ready for that question. So I did argue the equitable argument. In addition to the due process argument, I made another constitutional argument, which was that these rules and these regulations and these statutes are too vague to give a provider any idea about what's going on.
Let me ask you about one other argument that occurred to me. I mean, you did win the administrative appeal in both cases in the sense that your clients were not revoked. And the notice said if you lose the appeal, you'll have to pay back benefits or assistance or whatever. What about that argument that you actually prevailed?
So it's a very complicated case with a bunch of different things. What I'm actually appealing here today. What the judicial review on this basis was the fact that they tried to take back the money that they earned during the appeal. So the prevailing arguments underneath, I didn't represent Ms. Endress in her argument as in regard to her initial accusation by the department. I did represent Ms. Pfaltzgraff. They were, in both cases, both Ms. Pfaltzgraff and Ms. Endress were claimed to have had a safety issue, meaning they had too many kids in their care. I represented Ms. Pfaltzgraff. We went through the administrative process. We went through the ALJ, and the ALJ said, well, it's not a safety issue. We were able to determine it was a billing error. But the DHS decided that the decision to terminate the contract was still correct. Now, this is on Pfaltzgraff. Now, Ms. Endress, she defended herself, actually, in her case, which was 3 years prior. But she came to the same result. She was able to prove to the ALJ, I didn't have too many kids in my care. This was simply a billing error. So the DHS still considered that they prevailed on that level. Now, I didn't bring that up for judicial review because the way that it worked out, Ms. Pfaltzgraff was actually able to, she was going to have a 6-month probation based on the safety violation. Since we moved it out of that category, she was able to renew her contract immediately. So I thought, is it really worth going through the time and expense of judicial review? Yes.
In your view, is this a different case if the notice would have said payments instead of benefits?
I think that makes a difference as far as the interpretation. I think, particularly since the notice that the DHS is talking about was in the boilerplate of the document. So you have a notice.
So, and the reason I ask is, if I understand this correctly, both of your clients had to fill out an online form and check a box that said, I will continue to receive benefits with the understanding that the benefits will be repaid or have to be repaid if I lose the appeal. To what could that refer other than the payments that they were receiving? I mean, they elected to continue receiving something. Was there some other benefit that they were receiving that we're not aware of?
No, I think the distinction is that these forms and these programs, they're designed to kind of cover the groundwork. So they reach both the beneficiaries, which are the parents to these programs, and the providers. So, and I don't know specifically about the online aspect, but in the boilerplate that is attached to these notices, the DHS has admitted that, yes, these are sent out to both beneficiaries and providers. It's meant to be a catch-all.
But each of them affirmatively indicated that they wanted to continue receiving whatever it is they were receiving, whether you want to characterize it as a benefit or payment, subject to recoupment if they lost. Is that right? Again, I don't remember exactly what the phrase is, but I believe they did check a box on the computer. And
let me, on this notice issue, I mean, one thing that kind of jumps out at me when I read the record in both cases is I don't see any affidavits from your clients saying they weren't aware that they might have to repay the assistance if they lost their administrative appeals. I mean, wouldn't that seem to be a basic requirement if you're arguing they didn't know to have evidence from the clients as opposed to just a legal argument?
Yeah, so we went through the administrative review process with an ALJ, and I know during the Pfaltzgraff testimony, I believe she had some issues with the phone because it was a telephonic hearing, and so she got cut off. Ms. Endress did testify during that ALJ hearing that she wasn't aware.
She said
that's in the record?
Yes, I believe so. Okay.
But also in the record is the language in the document that they signed. And I know sometimes documents can be overwhelming, but it seems to me like it's pretty simple. May have to be paid back, whether you refer to it as a benefit or whatever it may be. Also, you are therefore allowed to continue to receive child care assistance funding, which has a money tone to it, pending the outcome. Any benefit you receive, even though they call it a benefit, ... may have to be paid back. Isn't that kind of writing it with big crayons?
And I understand that. I do have a little bit of a problem with the language in that phrase. It says it may have to be paid back. It doesn't say it will have to be paid back, first of all. Secondly, both of these providers, they overbilled for some of their services. In the case of Ms. Pfaltzgraff, it was $200. We estimate, because the DHS never told us how much they overbilled. We still don't know to this day. But in Pfaltzgraff, we estimate it was at most $218.18. And in the Endress case, I believe it was $600.
Would you agree with me, my earlier question of the other side, that what we're talking about is protective daycare?
No.
It's not protective daycare?
But it functions in the same manner. So this is the Child Care Assistance Program. So this is a federally funded program that if a person meets poverty guidelines or certain guidelines, that the federal government, through the state, through DHS, will pay for.
But isn't that the same program that DHS uses in juvenile court? They just call it protective daycare.
That I can't answer that.
Well, if it's federally funded and it goes directly to the provider and it helps families who are financially under that radar, doesn't that sound very similar?
It is very similar, and it's the same. The financials are handled the same way.
Is it in the record? Do your clients have private pay people, kids that are in their daycares that aren't being funded by DHS?
I think both of my clients do occasionally, but primarily their income is based on this program.
So how would you distinguish this case from the host of other cases where we've approved, or in other states have approved, recoupment statutes? So I think it's fairly common practice, for example, unemployment compensation benefits to continue pending appeal subject to recoupment. The same thing it provides for other types of federal benefits, state benefits. Why is this case different?
Well, and unemployment's a good category to deal with that, as is, let's say, the beneficiaries of this program, the actual parents. On unemployment benefits, the person isn't working to get those benefits. If it's the beneficiaries in this program, they're not working to receive these benefits. So they're not, it's a gratuity almost, as opposed to this is where.
But constitutionally, how do you make a difference? I understand that your argument is that there's an equitable case to be made that this should be treated differently, whether it's quantum merit or unjust enrichment. But on the due process piece of it, haven't we blessed already these kinds of recoupment statutes, and haven't other states done the same thing?
And this due process argument is based on the fact that there wasn't sufficient notice and the vagueness argument. So I think it depends on how you're approaching it from a constitutional standpoint.
Well, I guess you're claiming that she was on notice that any overbilling was, if found to be overbilling, she'd have to pay it back.
Well, and that's what I presumed by looking at it, because if you think about, from a logical, legal standpoint, if you go through the process and they found that you were wrong in what you overbilled, that's what you'd have to pay back. You wouldn't expect.
It's a gross proportionality problem from your perspective, I think. You fought the DHS tooth and tongue. You ended up with a $218 overcharge, maybe, and then you end up with a $31,000 recoupment.
Right, which
problem,
shocked me.
Which is kind of mind-numbing on one level. But you're probably charged with notice. In fact, I'm rather certain you are charged with notice of statutes and applicable regs.
You are, but I want to say on the notice, and again, I can't go and talk about the computer factor, but on the notice itself, it meets the 17A criteria where it talks about the statutes. But if you look back in the boilerplate, there's no reference to any rules that say recoupment is. What statutes justify recoupment. Would
you agree with me that DHS made some pretty significant changes in their paperwork between the two cases, and perhaps your argument may be stronger in the older case, the Endress case, on due process?
It may be stronger because they have made some changes, but I still think that the due process argument is there. And I think there's my other arguments as well, which, in addition to the void for vagueness, I don't think they have they don't have the authority under 237A or 17A to make recoupment provisions for this program. If
a recoupment is allowed, how else can they say it unless just plain not providing it? I don't think your providers would want this option to go away. It's a wonderful option to continue to receive payment, especially if they end up being okayed by the process and have nothing against them like a revocation. But how do you suggest the state proceed then if they want to try and prevent people from taking advantage of this? And rightfully so, if somebody has their ticket punched, perhaps for very egregious reasons, these don't seem to be so egregious, but it doesn't make sense that we should pay for something like that.
Well, and let me talk about 17A a little bit, which is the Iowa Administrative Act. 17A demands that a person get due process before an agency, before an agency takes away any of their rights. In a case like this, I would say that the DHS doesn't have the right to take away the ability of these providers to do daycare until they're given a hearing. That's one of my fundamental arguments. Now, as far as those maybe grievous instances where there's something very wrong with the daycare center, 17A18 actually allows for agencies to immediately, and for the purpose of public safety, shut down an entity or whatever it needs to do as far as agency action or licensing. 17A18 allows for immediate emergency action. So if the DHS wanted to pursue that, they could and immediately shut down. But it doesn't string people along to say, okay, keep working for us for free.
Can I ask you a related question before you run out of time?
Sure.
Is there anything in the statute or regs that indicates the state program would be at risk in terms of receiving federal funding if it authorized payment to people who didn't have the CCAP agreement? In other words, are they compelled to seek recoupment to maintain compliance with federal standards?
I haven't seen anything that requires that. In fact, I would say that the federal statutes encourages the DHS to try to find people to provide these services. The federal government has an interest in people doing this. And I think that this policy discourages that. Because just like this instance where there was a safety violation, and if they know it's going to be recouped, those people will stop. Ms. Enders and Ms. Pfaltzgraff are small business owners. They put a lot of time and effort in putting this together. They have parents that rely on them. And like you made the point earlier, Justice, if the DHS wasn't going to them, if they shut down their doors, they would spend this money elsewhere. And so that's why it's important, I believe, for this court to let the DHS know that programs like these need to be supported and not have these kind of detrimental actions taken against them.
In general, there's a lot of cases saying you can't get estoppel against the government. Do you have any authority that would allow an unjust enrichment claim under these facts? And if we allowed that, would it eviscerate the statutes providing for recoupment?
I don't think so, because this is my argument is for unjust enrichment. And so when there's been leniency given towards going after the government when there's a contract at play. And unjust enrichment is basically, it's based in contract. So I think the same reason would apply here. I don't think this opens up the door for equitable arguments in other arenas of law, but I think in contract it's appropriate.
Thank you very much, Mr. Nelson.
All right, thank you.
Mr. Thompson, any rebuttal?
Yes, Your Honor.
I want to ask you a question before you even open your mouth. You left your last conversation with something that was very interesting. I'd like you to pick up with that as if there wasn't a break. You said, maybe there's a remedy for the inequity. Tell me what you're thinking.
Well, I don't think it's this case, right? And so I think that Justice Waterman was starting to ask questions about equitable remedies in the state. And it's really not before the court in this Pfaltzgraff case, but there are restrictions. This court, law generally, the equitable remedies of unjust, promissory estoppel, unjust enrichment, and others rarely lie against the state. And there's a long policy reason for it. The other thing is, there's a contractual relationship here. We have a statutory scheme, a contract with specific terms, and yes, sometimes contracts can be harsh. This contract says payments are only going to be honored for the term that's effective of this contract. And so the
contract ended. If you're right, the contract ended.
It did.
And then what's wrong with unjust enrichment? If somebody came somebody provided some service at our building to benefit the courts, and we said, okay, there was no contract, but we're still not going to pay for it. Couldn't they pursue an unjust enrichment claim?
I think they could try. I guess that's not the litigation that we're here to try and resolve, because that's
well,
not...
maybe it is, because didn't they raise that argument below?
They did, but I pulled out Justice Rosenberg's decision, and he didn't address it. He expressly said the only issue before on review is the recoupment and the due process question. The other issues argued and presented by the petitioner are not presented for appeal.
I think I got you to agree with me, though, that it was preserved in Indus at the adjudicative level.
Again, I believe it was. I'm not here to argue that case. I'm familiar with
Yeah, but you brought it up first.
I did. That's fair, and that's why I think you're right, Your Honor. But I don't think we're here for judicial review, and I want to go back to like a fundamental 17A provision that we talk about all the time, which is there are direct original actions which you can file against the state, and there is judicial review. There's a line of cases from this court that says those two things can't be joined in the same action. So just like there are different ways to bring constitutional claims, but in the context of judicial review, there is a limited framework where the district court sits as an appellate court. It's an administrative law provision. There are things that you can raise there within the context of a judicial review, and there are things that aren't. And then in a separate original proceeding, another claim could be asserted. It doesn't mean that I'm agreeing that it would have merit or that it would lie against the state. So I think that's the remedy that we're all looking for, which is why I would just, I'm sorry, go ahead, Your Honor.
Let me throw out another thing. As I read some of the DHS notices, at least, and they did say if you lose your appeal, some benefits, assistance, depending on the notice, depending on the time frame, may have to be paid back. There may be recoupment, but they always talked about the case in terms of revocation, and on that issue, both of these providers prevailed, right?
No, I mean, I think that's I want to get back to, because you asked this question at the very beginning. There are two pieces.
And it still bothers me.
There are two pieces of the puzzle. One is the registration that deals with having a child care home. You can take private private clients. The child care assistance program is separate. It feeds into the system of child care that is subject to licensure and registration. But the trick there is there's this assistance, and under 237A13, the legislature has said that those services may be provided by a provider, and then sets out how that works. And so that contract that is the part of the billing and payment system for being a provider who can provide the services and receive the assistance is caught up in the contract. The contract is, in fact, a requirement for you to be able to receive the payments at all.
The difference mattered to DHS. It mattered to both Ms. Pfaltzgraff and Ms. Endress, and maybe it matters to us as a court, because if what happened was a revocation of the registration, then I could see DHS's position. This was an unsafe daycare. We shouldn't have to pay for the services provided pending appeal by an unsafe daycare. But if the only issue is there was a billing problem, then doesn't Mr. Nelson have a point? You ought to pay for the services, but for the overcharges.
I understand the issue. Let me address that. I mean, I think that's an oversimplification of the record. The actual the decision is part of this record, but the finding, the reason that it was a split decision essentially is they thought that she was taking care of too many people, that she had exceeded the capacity of her child care home. I mean, look in the paper for what so that's a severe safety issue, right? Her defense to that, and the reason she prevailed on that was, oh, I don't have too many people. Here are a bunch of affidavits of people who say the people that I billed you for weren't there. So her defense was, I billed the state for more people than I have in my home, which is an express basis for termination of the provider agreement and would entitle the DHS not to renew the agreement going forward. So again, in the context of recoupment, fiscal responsibility, and an entitlement program where a lot of federal and state dollars flow, what we have is a provider who essentially pled guilty to filing incorrect claims and billing for more people than were in her home in violation of any number of rules that required the reporting and accurate. Does that make sense?
Can I ask a follow-up to that as well?
Yeah.
And this goes back to your earlier point of this is not the appropriate vehicle to litigate the unjust enrichment claim, quantum merit claim, et cetera. Is the record adequate here to even address that, given what we know about the past billing practices?
No.
Like, I would assume the state would want to make an argument, well, we want to talk to the people that you claim to provide services for, even if we were going to gauge that in some other case.
Well, in an equitable proceeding where the equitable remedy is appropriate. It's not appropriate here. So, yes, there's not an adequate record. I know my time is up. There's just 2 corrections I want to make on the record just to make sure. So,
Why don't you do it very quickly?
Thank you. I mean, we talked about notice, good questions, but there are other notices at Appendix 195, Appendix 196 that are letters that don't use the word benefits or specifically say that what we're talking about is stuff related to your provider agreement, child care assistance funds, you're no longer eligible, overpayments may result, and there's another letter which is specifically at App 196 where it says that the benefits we're talking about are the child care assistance payments. So, I mean, the collective notice, in addition to the contract that she signed at the beginning, make it absolutely clear that overpayments or payments made during the pendency of an appeal would be recouped. Thank you.
Thank you, Mr. Thompson. The case is now considered submitted. You may adjourn court. Or recess court, I'm sorry.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.